Good afternoon. Let me just quickly tell you the background for this session. We had access to what you can see in front of your screen now. Okay. This is the question paper, as you can see. We got access to a document from one of our students who had taken the exam. Now, this is the student's answer sheet, and you can see that he had scored 36 out of the designated marks, and because of which he actually expected to clear this exam, but he couldn't clear it, and he scored really good marks in paper 1. And because he couldn't clear it, he took an RTI and he got a copy of this. So we will be analyzing this, but I want you to understand that here is a person who has industry experience, who has been working for quite some time and has substantial drafting experience. And if you see C1 and C2, he has scored well. You can see that he has scored 29 marks just out of C1 and C2. And in part A and part B, he did not fare really well. So our analysis here is going to be, we are going to focus on, I just need to admit some more people. Hold on. So also I would advise you to mute your mics, because this is a platform where people can speak. So I would advise you all to mute your mics. So what we are going to do today is we are going to look at what made this person not clear the exam. So we are going to see how he had answered it, and we will also be showing you the question papers. We have the question paper here, right here. Now this is one of the answer sheets that we created, and these are the question papers. So I'll just let my colleagues take over now, and I will also be giving you certain feedback at the appropriate point. But this analysis is interesting because you will see that a person who had substantial experience in the industry, who works for an enterprise, a company which files patents, you can call it a multinational company. I mean, we can't disclose more than that. He could not clear paper 2, despite scoring extremely well in the drafting session. C1 and C2, he scored 29 marks, but still he couldn't clear the paper. Now let's look at what went wrong so that we can learn the lessons and ensure that the same mistakes are not repeated by whoever is going to watch this and get benefit out of this. Now, I may have to constantly, you'll have to constantly keep adding people here. So what we will do is we'll just proceed with the analysis. So I will just give it over to my colleagues, Roshan and Venkat, who will explain this paper.
Hello, everyone. Good afternoon, Roshan. Thank you, sir. So Roshan, we are going to, why don't we first show so this is all about the 2016 patent agent exam. And Roshan is going to first display the question paper for 2016 exam, so that we first, let us take a quick look at the question for paper 2. And what I heard was that this candidate, he has successfully cleared the paper 1 part, and paper 2 is, as you can see. Okay, so let me briefly discuss the features of the paper 2. So paper 2 has 3 parts. Part A, 20 marks, and part A has 4 questions, and each carrying 5 marks, and part B, 3 questions, 10 marks each, and part C, 2 questions. And so at least in part C, you have the option of choosing one or the other, and each question carrying 25 marks. So part C is for 50 marks. So paper 2, as you all know, that the major part of paper 2 is focused on drafting, but still it is more focused on the other, the 50% is focused on the situation-based question. So here we are going to discuss how well the candidate has done on the situation-based question. And before we begin, so I hope you all can see this is the 2016 paper 2 and part A. So maybe I'll let Rosh. Okay, just we have to admit few more people. Great. Okay, now we are all set. So Roshan, why don't you show the answer key, the first page of the answer key? So
yes, sure, Venkat. Let us look at the answers
yes.
given by our candidate last year. So to the first question, he has done it part wise, so it will be easier for us to even analyze the paper. So let's go part wise. So part A has 3 questions, each of four questions, each of 5 marks, which comes to a total of 20 questions. The first question relates to, it's a situational based questions where a problem is given. The problem relates to, there are two inventors, A and B, both are co-inventors. Then later A files an application for a patent in his own name, and B comes to know about this fact from the Journal of the Patent Office. Now the question is, what action should B take to redress this injustice inflicted upon him by A? So this is a pretty straightforward question. It's talking about section 28 of the Patents Act. So now let's see what the candidate has given for this answer. Venkat, could you please go through it?
Yes. What I liked about the answers here are, first, the candidate has listed out the facts. I think it is a good approach here. First, list out the facts, which clearly says that you have understood the questions. So that way you get the option of expanding the section better. So if you see that, scroll. So the candidate has listed the A and B are the co-inventors. A files the patent alone without B as the co-applicant. So this gives him more clarity to understand that which section he has to look up to, and which is clearly section 28 is the section where it talks about the mention of the co-inventors, or if there is a dispute or anything. So so the way the candidate has explained the answer is, as per the provisions of the Patents Act, the applicant can approach the controller clearly stating the parts of the claim which applicant has failed. And he also emphasizes on section 28, saying that applicant B can appeal to the controller in writing to the controller in the prescribed form with the prescribed fee. The form number is 14. The controller will look into the objections raised by the applicant and notify applicant. So, and Roshan, can you quickly check how much the candidate was awarded?
Venkat, he was not awarded any marks for this question. He has written the sections right, but he got the rule and the form completely wrong. And he was not awarded any marks in this particular question.
Okay, so what this clearly tells us is that it's better off to mention the sections or the rule or form if you know them back of the hand. But here he got the section right, but somehow he got the rule or the form number wrong. So if you see that he has listed, he listed the rule as 51 and the form 14. However, the relevant section here is 67 and the relevant form is 8. So this throws a bad light on the candidate. So right away, the person who is grading the exam would right away think that, no, this candidate may not know more about this section. So instead of reading through the descriptive part, he might right away strike off the answer, giving 0 marks to it. Maybe that is the reason why he was given 0 marks. Though he got the section right, the rule and the form is totally off. I think this is a good point to make note of that.
Venkat, could you also tell us what is the relevant rule and the form here?
The rule here is, as I mentioned, the rule is 67 and the relevant form is 8. And it's way off. Form 14 is not the relevant form here. So I mean, that clearly puts off the grader, who thinks that really puts off the grader, and he clearly thinks that the candidate does not know much about this question. So it is a good practice. If you know the sections, rules and form right, better mention it and then go on to describe the answer that you know.
Right. So thank you, Venkat. Moving on to the next question. So question 2 of last year's paper. So question 2 is, Y owns an Indian patent. X requests for a license under the patent from Y. Y imposed certain conditions such that X cannot acquire such articles which are not covered by the patent from many any person other than Y. Y also imposes a condition of exclusive grant back in the license. Now, this particular applicant has, as an agent, do you think that these conditions are appropriate? So the applicant has approached you to give whether, using the relevant provisions of the Act, whether the certain conditions are valid or not. So last year we saw that there are a lot of people who misunderstood this questions and question and took it for this license to mean as compulsory licensing. But that's not the case here. This license is not a compulsory licensing, but rather a voluntary license issued by the applicant to a licensee. Now let's see what the candidate has answered in this. Yeah.
Yes. Going from the positive side, which the candidate clearly cites the facts related to the question, which is Y owns the patent, X requests for Y for the patent license, and what are the terms and conditions that are not acceptable. And as you can see that the candidate right away thought of the compulsory license. So this is a slightly tricky question. Unless the word compulsory is mentioned in the question, or if there is any sort of emergency, a natural disaster or anything, otherwise it's the regular license they are mentioning. So that is why he right away thought that maybe that the question is related to a compulsory license. So as you can see that he goes on to explain about the compulsory license, and also he mentions the rule 91. And if you can recall that the relevant rules are 96 to 100 here, if I'm right. And so, and then he lists out the facts behind compulsory license, but he got entirely his way off from what was asked in the first place. And maybe that was the reason why he was given 0 marks for this, and rightly so.
Right, Venkat. So could you please also tell us what's the relevant provision that the candidate should have mentioned here so that he could get the answer right?
Yes, sure. Can you go to the next tab? So where we have the answers for this. So here is the best practice, or this is the suggested practice. So you can clearly see that the relevant section here is 140, which is the avoidance of certain restrictive conditions. And as you can see, the descriptive part here, which is to the point, which says the Patent Act clearly stipulates certain conditions to be unlawful. And then it clearly says that the Section 141A prohibits the patentee from restricting the purchase of articles other than those the patent covers by the licensees. And also 141D clearly instructs avoidance by the patentee from imposing any exclusive grant back. Hence, these conditions imposed by Y on X will be deemed unlawful. So clearly, this is the case of the regular license, which falls under Section 40, and it is misleading that if you assume that this is related to a compulsory license. So that was the reason why he was given 0 marks. So again, this is to emphasize the fact that you have to read the question properly and make sure that you catch each and every word of the question. And instead of spending and wasting your time on completely writing about an irrelevant section, it is better to understand the question right and spend time on answering it wisely.
Right, Venkat. So as I see, both the two questions were completely straightforward right from the Patents Act. So if you are thorough with the Act and the rules, and if you are even thorough with the what terms used in these sections, you could easily get these answers correct. So moving on to the third question. The third question relates to a international application filed under a PCT. So the applicant files a patent application in India and then approaches you the patent agent, to file an international application under the PCT. So he has some specific questions on the following. The first one was whether he can claim priority on his application filed in India and within what time. Second, when he can file a national phase application from PCT route. And third, after filing of national phase application, what would be the fate of his previous application? So let's see how the candidate has fared in this.
Okay, so if we flip to the third question. Okay, so if you see, if you had observed that in the first two questions, the candidate had clearly listed out the facts and unusual to the 1 and 2. Now right away he goes on to explain the descriptive part of the answer. So he doesn't mention the section, which I don't see it here. Do you see a section where he has mentioned?
No, I don't see a
Okay,
section.
so he has not mentioned the section, and if you recall, the relevant section here is section 135.3, and that is related to the question number 1. Can you flip to the question part so that we want to make sure that he has answered the part A of the okay, the part A of the question is whether he can claim priority of his application filed in India, and within what time. Now if we can go to the next tab. Yep. Great. So this is what I was mentioning. The relevant section is section 135 subsection 3. So to claim priority from the earlier application has to be file an international application under PCT within 12 months. So the earlier application will be treated as the basic application. This is the ideal answer, but can you flip to the answer that the candidate wrote? Okay, so here again the candidate mentioned that the inventor has filed an application in India, assume it is a complete specification filed with relevant forms, and he clearly again he got the timeline right. So he mentioned that the inventor can file a complete specification by filing international application under PCT within 12 months from the date of ordinary application filed in India. So he got the timeline right, which is the catch here. So he got the timeline right, and the inventor can claim priority for the application filed in India. The application should have filed within 12 months from the date of filing an application in India. So he has covered every aspect of this question. So which is fine. So can you go back to the B part of the question, when he can file a national phase application from PCT route, and which is the part B. So the inventor has to request for exam. Okay, so he goes on to explain about the examination and the publication, which is not asked for, which means that if you can recall one of the webinars where professor mentioned that time management is key here in paper 2. So you spend at least 5 to 10 minutes on this answer which you are not asked for. So you are deviating from the question. And the relevant answer here is the inventor can file a national phase application for PCT road before 31 months. And that is precisely the question that was asked for. So this hardly would take 2 minutes. So you would have invested more than 10 minutes going on a different route. And going to the part C of this. Yeah. So after filing the national phase application, what would be the fate of his previous application? And the overall, please advise him as per provisions of PCT and the Indian Patents Act.
Okay, so yeah, after filing of the national phase application,
yes. So the answer that it's expected is a request for examination under Section 11B made for one of the applications filed in India. Therefore, in the absence of not filing a request for examination, the previous application, so they are asking for the previous application. So in the absence of not filing a request for examination, shall be treated as withdrawn by the applicant. So this is one of the Section 11B subsection 4. And whereas if you go back to the answer the candidate wrote, so he says the inventor has to file a national phase application within the respective candidate.
He goes on to mention about the timeline in the PCT, and that's completely irrelevant and
right.
Not a part of the question.
But the catch here is he got the option A, so part A and B, right? And that is the reason why he got 3 marks out of 5 marks. And also I like the fact that he clearly mapped the PCT filing process, which is this really informs the grader that the candidate knows everything about the PCT, and maybe that is also one of the reasons why he got 3 out of 5. Move on. Let's move on to the next question.
Yeah, the next question deals with startup and small entities under the patent rules. Let me mention here, this question was asked in 2016, and since 2016 the rules have been amended again. So the answer here will be the candidate has written the answer according to the 2016 rules. So the present rules mention that according to Rule 2FB, the startups is an entity as prescribed by the DIPP. So each and every time a DIPP comes up with a notification, it comes up with a definition of startup, and the Patents Act Patent Act and the rules will use that definition to interpret what is a startup. So let's see how the candidate has fared according to the last 2016 rules.
So I guess we have to flip through a few more pages. So he got the answer in the later part. Okay, so this is the answer. This is the most descriptive out of all the for all the questions he has answered, and he got almost everything right. So he got the facts right, but as Roshan mentioned, so this was amended. So this may not be the right answer for now. So if you scroll up. And he got all the facts right, but one thing that catches my attention is that he in the first part he clearly mentioned that under 2FB, so he clearly says that is the rule 2FB, and then in the later part, which is according to section 2F of Indian Patents Act. So do you see that he got there is a mismatch here? So in one place where he says it's rule 2FB and it is not section 2F. So these are the things where you don't want to showcase this to the grader, that you are little confused about which section of the rule you're planning to write about. And so he got 3 out of 5 here. And if you scroll to the next page, and so also the question is also what are the benefits a startup are entitled for. And so one of the key benefits is that they can request for the expedited examination, which was clearly mentioned here. And the candidate also goes on to explain about the small entities. So this was really well done, nicely answered. And that was the reason why he was given 3 out of 5. So Roshan, before we move on to the section, can you scroll up to the first page so that we can give an exact split of how much he got out of 20 here. So this is part A of paper 2, and I think the candidate got, yes. So if you see this part, so part A, so he got 6 out of 20. And if we move to the next part, which is part B, and if you recall, part B has 3 questions, and the first question is about the section 3D.
Yeah, so the question is on section 3D of the Indian Patents Act, which talks about the explanation to section 3D, where salts, ethers, esters, and polymers, and any other related substances would be considered as the derivatives of the known substance, shall be considered to be the same substance. Now here, the question asks to explain the term efficacy in the light of the judgment of the Supreme Court and other relevant orders by different courts in the matter of Novartis versus Union of India, involving an anti-cancer compound. So the question talks about 2 cases, particularly Novartis case in the Supreme Court as well as the High Court. Those are the 2 decisions where efficacy had been discussed by the court. Yeah, so this is a theoretical question which the candidate would have been required to list out the facts of the case, what led to the decision, and then explain how efficacy has been described by the court, which the court has said that efficacy relates to therapeutic efficacy. And yeah, let's see how the candidate answered this.
Okay, so on my experience with the podcast, so one of the patent agents who successfully cleared the 2016 exam mentioned to me that this was a surprise question for them because this involved a case law. It looks like here and there could be questions on case law, so it is a good practice to be you should be aware of important case laws. If you can show the answer, Roshan. I think he answered in the last few pages. We'll come to the, yes, okay. So this is, I mean, here you don't have to mention the section because the question already carries the section name. So all they are expecting is what exactly the efficacy means. So here he goes on to explain about the mere admixing of the substance which does not result in enhanced efficacy of the substance. Said substance is not patentable. If I recall, this is not the section 3D. So he jumps to section 3E, and the combination of substance which does not yield any improvement in the property of said substance is not patentable. Again, he rewords section 3. So clearly this is not the answer that was expected. The expected answer is what exactly the efficacy means. So you have to explain related to the efficacy part. So that was not the answer that was expected. And with the no enhancement of the said substance to the combination of the components, doesn't yield any improvement than the result of the combination of the substance. So it is all about section 3. And rightly so, the candidate was given 0 marks for this because there was no explanation on efficacy when it was expected.
Venkat, as you mentioned earlier, there can be a few surprise questions on case laws. So I think the only 3 possible case laws that can be asked that relates to patent law and that's important is, one is Novartis case, the other one is Natco Pharma versus Bayer, that's the first compulsory licensing case in India, and third one is an IPAB decision of Yahoo and Yahoo case, which relates to business methods. So if you know a bit of these 3 cases, know the decisions of these 3 case laws, I think that we have covered most of the important case laws in the country.
I think, Roshan, we covered the Natco Pharma case related to the compulsory license in the podcast. So those interested can go back to the podcast to listen to that. So let's switch to the next question, question number 6, which is the...
Question 6 is Question 6 is a situational question where A invents a medicine which is a combination of components A, B, and C. Component C is a powder of herb which occurs in hilly terrain of Assam and adjoining areas. As a patent agent, advise him regarding the essential procedural and substantial aspect of patenting of such combinations. Now, Venkat, before we move on to answering this question, one best practice or one suggested practice that we can incorporate while answering situational questions is using the IRAC method. That is which you use commonly in law school also whenever there is a fact-based question where you have to apply the law into the set of facts. So what is the IRAC method is I stands for issue, R stands for rule of law, A for analysis, and C for conclusion. So after reading the question, we have to see what is the issue, what is the facts in the case, and what okay, the relevant law.
Yeah.
I just repeated it.
Yeah. So the best practice is to follow the IRAC method. I stands for issue, R for rule of law, A for analysis, and C for conclusion. So whenever there is a question on a situational based question, you have to first identify what is the issue. How would you identify the issue is go through the facts and see what the question is asking for. Now, once you have identified the issue, the next thing that you have to write down is what is the rule of law. Rule of law here would be the relevant rules and relevant sections of the Patents Act and the rules that would be necessary to answer the particular question. Now, once you have the rule of law and the issue in place, you have to apply that rule to the facts in hand. That's the analysis part that you have to do in your paper. And once you have done the analysis, you have to conclude the answer. The conclusion of the answer would be answering the question that has been asked. So yeah, Venkat, let's see how the candidate has done here.
So we'll be posting this answer key after this webinar along with the transcript. Maybe if we flip to the, yes, okay. So here we are. Great. So again, we go back to the place where we started. So again, he lists out the facts where A is the inventor, A, B, C are the components, and C is the herb. So right away, it jumps to you that this should be related to section 3P, but you see that the candidate starts off with section 3Q, which is not the traditional knowledge. So there is nothing as section 3Q in the Patents Act. So that's not a good start to have. And then the component C is used as a mixture of the combination of components B and C. And if the component C produces any change with the method of preparation, which changes in combination with B and C by heat, etc., are patentable. So, can you scroll down a bit? Okay, great. So he goes on to again explain section 3 of the Indian Patent Act has the exclusion list from subsection 3A to 3P. And 3B to 3. So, I guess the candidate was given 1 mark out of 10 marks, and I think he quoted the section wrong first instance, and all he was expected here is, okay, so this is the right answer, the ideal answer. Okay, so as you see that, so this is about the combinations. When considering the combinations, you should always think about the section 3 of the Patents Act, and 3 outlines that are patent according to Indian law. 3 specially states that a substance obtained by an admixture resulting only in the aggregation of the properties of the components or a process for producing such substance. And he goes on to explain the other herbal component, which is the component C. And as you know that, so it should be section 3P, whereas the candidate quoted the section wrong. So the candidate mentioned 3Q, and the right provision is section 3P. And according to 3P, the traditional knowledge or the aggregation or duplication of known properties of traditionally known component or the components. So again, I would like to reiterate the fact that it is better to quote the sections, rules, and forms if you're 100% about this. Otherwise, it is better to avoid quoting it, rather go to the descriptive part of the section. That is what we get. We are not suggesting that, but that is what we take from this answer key. Yes, Roshan.
Source.
And also the source. So as you know that in this case, the National Biodiversity Authority needs to give permission for the invention to be found in order for the grant. A request for permission can be filed in Form 3 upon payment of fees, and fees is also mentioned here. I'm not sure whether it is a good practice to mention the fees if you're 100%. Otherwise, it is better to avoid mentioning the fees. Maybe Professor can throw more light on this later.
Moving on to the next question, question 7. It talks about a patent was granted to X on a communication system. After getting the patent, X serves a notice of infringement upon Y on the ground that he was infringing the patent granted to X. Y approaches you for suitable advice. Please explain to Y the remedies under the Patents Act. So I think he has not attempted this question.
Okay, so this is related to the sections 104 onwards. And yeah, so this is related to section 106. So we'll post the answer key also. So we'll not be explaining the entire answer key. So you can take a look at this answer key later. And if we go back to, right, okay. So this concludes the part A and part B of paper 2. If you can scroll back to the first part of the page, the answer key. Yep. So out of 50, let's look at how much the candidate had scored. So the part A, he has scored 6 marks, and in part B, he managed to score 1 mark. So out of 50, he managed to score 7. And as Professor rightly mentioned, so the candidate here was a patent professional, and he scored 29 marks in the remaining 50 marks of the drafting exercise, which means that he lost many in the part A and part B. So it is better to be completely thorough with the sections. And again, I reiterate that you mention the section, form number, and rule number if you are 100% sure about it. Otherwise, just go on to explain the descriptive part. Now I'll hand over it to Professor Ferozari.
Thank you, Venkat. Thank you, Roshan. That was a crisp analysis of what the paper looked like. Now, I just was a point which I've been reiterating for quite some time. Many of you would have done your basic graduation degrees. Some of you may have masters. I know people who have their PhDs who are taking this exam. But nevertheless, this is a point. It's a point which they emphasize in schools and in colleges. This has to be driven down. Now, when you look at part A, B, and C, part A and B carries 50 marks and part B carries 50 marks. So logically, you should be spending equal amount of time on all these parts. So the best practice would be to allocate time based on the marks. And as soon as the time runs out, say you have allocated 1.5 hours for part C, start writing part C, read the question multiple number of times. You would have seen the benefit of reading the question, the one on compulsory license and on voluntary license. You have to read the question. So reading the question and understanding is a part of the time that you're going to take in answering the paper. So if you have 1.5 hours for part C, then at the end of 1.5 hours, regardless of where you are, you should move to the other part. So if you have, say, allocated 45 minutes for part A, at the end of the 45 minutes, which means you have 4 questions, so roughly you are going to spend about 10 minutes on each, slightly more than 10 minutes on each answer. At the end of the 10 minutes, you have to move to the next answer. There is no way you can just sit and say that I will write a great answer, I'll add more information, because no matter what you do, you are not going to get more than 5 marks. So bear this in mind. You have to proportion the time based on the marks. And once the allocated time, you have to have an internal allocation of time. Once you cross the time limit, move to the next question. At least attempt something there. At the end, you will find that you will have some more time, because you will see, if you saw the way this candidate had answered the Novartis case, he had answered the Novartis case after answering part C, which means the person had actually left time to come to certain things which he was not conversant. We can make that assumption. And you can see that the answer was not up to the mark. Now, that's one way to do it. Finish whatever you know and then write probably the weak answers or the answers you're not sure at the end. The other way is to leave space. There is, in an answer sheet, you just leave 1 sheet or 1.5 sheet for an essay type question. Drafting may take, you may need more time for more space for writing the drafting part C answers. So you just leave the space and go. But this is something which I've heard from people who have written examinations number of times. People who have cleared their PhDs could not manage time when it came to paper 2. So bear this in mind. Before you go, you should have a time allocation based on the marks. Part A, 45 minutes. Part B, 45 minutes. Part C, 1 hour 50 minutes, 1 hour 30 minutes. So once you have this allocation, at the end of the time, you just need to move to the next part. You will always have some time to come back, but the point is you have to do justice to all the parts. Otherwise, you're going to have a lopsided mark like this. The person who I personally know, he's a guy who should have cleared it in 2016. In all terms, he knows the patent law well. He has base experience, everything, but probably something went wrong in management as well. Presentation is one thing which we want to focus on this in this webinar, but also we also want to focus on how you manage the time. Now, a couple of things. We don't want to get into a detailed discussion on this, and as you saw my colleagues answer this, one thing I want to add on with regard to the first question. It's an open-ended question. It just says that there were 2 inventors, one person files, what are the remedies of the other? Now, if the other person is only aggrieved by the fact that his name is not mentioned, then he can resort to section 28, saying that my name is not mentioned, he should mention my name. But the question doesn't appear to stop there. The question seems to say that the one person was left out as an applicant, in which case you have a remedy under section 25. Section 25(1)(a) allows you to make a claim that the invention was wrongfully obtained. Now, again, wrongfully obtained, you can't say that if you're the co-inventor, you can't say that it was entirely wrongfully obtained, because he is also, the other person is entitled to 50% of it. Now, Section 25A also has an inherent disadvantage if you move in using Section 25A, because the remedy you can ask for is a refusal of the application. But 26 tells you that you can step into the shoes. The 26 actually tells you that if you have the rightful claimant, then you can step into the shoes and you can become the applicant and you can take the application forward. But that is more in the context of a post grant. But by implication, you could say that this will apply for pre-grant as well. So the point is, the question sometimes may be open-ended, and it is better that you bring all the layers of the answer if it is multiple, if it is open for multiple interpretation. So here is an issue which you can answer by 28, but that will be only the part answer. You can assume that there was an invention related dispute between the two people, and you can say that it can also be raised as a Section 25 dispute. Okay, please switch off mute your mics, because this is so that there is no disturbance. So that's one thing. Now, I just want to quickly run through, my colleagues have just covered what went wrong, but we also need to say what went right in this paper, because this candidate had good experience in drafting, and he actually scored quite well in drafting. So if you see, we will be sharing this paper with you. He scored 29 marks out of 50, which is if you ask me, it's close to 60% when it comes to drafting, and he did a decent job there. So you can see how he had answered it, and we cannot suggest anything better here. Probably in one of the webinars on drafting, we'll get to this. Now look at the way in which the claim 1 is drafted here. Now, a lawn sprinkler to distribute water evenly over a wide area, said lawn sprinkler comprising A, B, and C. All the parts are mentioned. And he has different types of claims. A dependent claim. 3 is again a dependent claim. Then he has a wherein claim. Claim 6 is a wherein, where it qualifies a component. So another way to look at this could be to have a mix of claims. They can be a product claim. They could also be a process claim if the invention allows you to do that, and you can have dependent claims as well. So because this is it carries 25 marks, you could have more details that come out. So there is nothing much we have in part C2. Again, he scored fairly well. He got 17 marks here, and you will see that this actually comes out from a person who has description of drawing is excellent. Figure 1, figure 2, figure 3. So this actually comes out of a person who has actually had some experience. But the irony of the story is that despite being a brilliant candidate, having good experience and knowledge of the patent law, he could not clear it last time. And we largely attribute that to two things. One, the way in which the answers were tackled. It is on, if we just told you that the amount of details, especially what Roshan had just told you, that the IRAC method, first bring out the issue, then bring out the legal provision, then have an analysis of it and your conclusion. Then now this would actually let you articulate the answer in a better way, and which is the most suitable way to approach situational questions. And also you have to be at some point conversant with the sections and the rules. If you're not really conversant about the sections, then you can avoid mentioning them. But the best answer will be where you can confidently state what the rules are and the sections are. Okay, so now that is something which we wanted to just share with you. I know we had some issues in getting to onto this platform. We had some technical snags. What we will do is we will be making a video out of this, and we'll be sharing it with you so that people who had missed out, and I saw that some of you were able to only join late, so you get the full benefit of this. It may require some editing from our end, so we will do that, and just give us some time. And another issue which I wanted to tell you is that we have had so far more than 100 queries raised on the forum, on the LexCampus forum, and there have been more than 250 posts. clarifying and answering them. So and we find that that's a better place to answer queries, and we have been focusing on answering your queries on the forum because of a couple of reasons. One, a query that is answered on a forum is searchable, whereas if we answer it on a video, you may have to watch the entire video to see what we answered. Two, it becomes possible for others to raise any follow-up questions. Say you understood priority, but you still had your doubt, and you can see in the questions on priority, after many days, after we answer a question, somebody else has a follow-up question. So it becomes easier for us to handle that. And we can also cite all the relevant provisions and even give hyperlinks to it. So for all these reasons, we find that, I mean, out of our experience, we find that the forum to be a better place for answering the questions. So please, as you have been, we have more than 200 responses there. So it's a rich database of questions. Please keep raising your questions there, and we will be happy to answer them there. Okay, so so now we will just, we just have 5 more minutes. If there are any questions pertaining to this, you can just raise it in your chat, the chat box. Okay. As I mentioned, it's always better, even if you have a question here, because it's much beneficial for all the others, so that your question can be seen and we can answer it in greater detail. So we will sign off now, and we will hopefully have another webinar sometime next week. And there is on how to tackle. Yeah. Okay. There are questions. Okay. We'll just look at that. Okay, I can see the questions now. Figure number in claims, should we mention element number in claims? Yes, whatever is numbered in the figure has to be described in the brief description of drawings. So if there is a figure, your answer should have a brief description of drawing, where figure 1, figure 2, figure 3 is explained. And in the description, you're going to describe the parts as well. So the answer is, you have to describe the elements with the number in the claims. Number in the claims, again, if you see Rule 13, which was amended recently, it says that you have to mention the numbers in parentheses. In brackets, you have to mention. That's there in Rule 13. Okay, whether this candidate has cleared the paper. No, the candidate didn't clear the paper because the candidate got only 39 out of the required marks. So he didn't clear the paper, and that's the reason he took an RTI. Nobody takes an RTI when they clear the exam, right? So that's the reason he took the RTI. And we were also quite surprised, because he's a person who ought to have cleared the exam. Do we need to figure our forms? That question is not clear. Can the person clarify that question? Do we need to figure our forms? Okay, mentioning case laws in the answers, will it be of use to improve marks? Now, the basic rule is this. When a question asks you what needs to be answered, please answer that. That's the minimum. Now, if you want to flaunt something, be very careful that you are confident about what you're going to say. That's only advice I have. If there is a question on 3D, you have answered 3D, you have covered all the points, you are entitled to 5 marks, and you have some time and you want to say what the Supreme Court analyzed 3D, what is Justice Alam's view on the distinction between invention and patentability, please go ahead. But you have to be sure when you're saying that. What is the best practice to write claim? Either device first and then method. Kindly clarify. See, there is no best practice per se. If the inventive part is, if it is product centric, let me put it this way. You're claiming the product first. You can claim the product first and then have process claims later. There is no harm in claiming the process. It's a strategy. You will find that in some cases, they first give the product, the title will cover only a product. And the first claim will be, the title will cover only a process. The process, it'll actually look like a process claim. Then the first claim will be a process claim. And the 20th or the 25th claim could be a product claim. This is a strategy which people employ, but the law does not require you to have the product claim first or the process claim first. It's completely left to how you arrange them. time allocation to abstract, as we have to write limited time writing. Okay, abstract has a limit. You can't write an abstract for more than 150 words. So what you could do is, in practice, I know many practitioners who write the abstract at the end. The abstract is always written at the end. So what you can do is just leave 5 or 10 lines, whatever is required for abstract, complete your claims, come back to the abstract, because your abstract can be even be a summary of your claims. And the major parts of the description and summary of the claims can be your abstract. So abstract, you can just leave space, go ahead, complete the thing, and come back to it after you have drafted the claims. In drafting part, do we need to figure out forms, or simply we can end up mentioning the section and the rule? See, there is only one form for drafting. Life is made easier. That is only form 2. There is no other form that is relevant for drafting. So if you want to mention a patent specification, a complete or a provisional should be filed under form 2, that is fine. But the question is on drafting. So you have to start with the drafting. If you want to mention rules and provisions, that's actually not required. Because when you remember the days where we were asked to write a letter, an official letter or a personal letter as a part of English composition, we don't say that, from address should come on top and, we date on the right hand. We don't say all that. We just get to it because the proof is your drafting, the work that you have drafted. So similarly, there's no need for you to mention because that could be, that could take a toll on your time. So what you will do is you would just go ahead and draft it without even citing the provision, especially when it comes to part C. Can we have a list of important case laws? We already have. In fact, if you have access to our handbook, we have already mentioned the important case laws there, and notice is always important. So what we would advise you is that the important case laws are what Roshan had mentioned, and notice is an odd case that has come. Right now, since notice, there has not been any Supreme Court case on patent, so we don't expect the patent office or the patent agent examination to ask High Court or IPAB decisions. There is one case that is pending before the Supreme Court. I'm not sure whether the decision will be out, but I'm reasonably sure that the question paper should have been set by now, because we just have 2 or 3 weeks for the exam. That's a case involving Monsanto and Nuzividu seeds. Again, Section 3J of the Patents Act has been questioned, but the date has not been fixed. So for all practical purposes, I don't think there will be any question on that, because the Supreme Court will take its own time. Now, do we need to draw forms in answer? No, do we need to draw forms in answer? Form 1 and Form 2 for, yeah, I'll mention that. As I said, in drafting, you need not say in which form you are drafting, because you are just drafting it. So it's not needed that to say that, or you can, if you want to say that, Form 2, because almost every specification, the title sheet says it's Form 2. So you can mention Form 2, that should be enough. What is the main focus on the sections to be aware of, important sections to be aware of to pass on the paper? We have tons of material on this. Whoever asked this, you have to get into some of our, at least the YouTube videos, where we have a split up of the important sections. Those videos are already there. And if you want a rough estimate, I would say that the first 100 sections are important. To just give a rough estimate, because all the things that happen within the patent office come within that timeline. Infringement happens after that. So if you want to understand the question paper is more focused on the first 100 sections. Can we write more than one independent claim? Yes, you could do that. You could do that. See, you don't worry about the number of claims, because if you are actually filing a patent application, if you go beyond 10 claims, your client will have to pay. Here, you can go beyond 10, 20. There is no curb whatsoever, but keep an eye on the time, because claim drafting is a time-consuming process. So if you can just have 5 claims, I think that should do the job for you. One independent claim or 1 or 2 independent claim. They can be a product claim that is independent, a process claim that is independent, 2 or 3 dependent claims which are dependent on that, just to show them that you know how this is done. Please share the sample drafting answer right from title. We'll be sharing this paper, so you will get a copy of that. Claim should be functional part of the not concept. There are some comments. I'm just skipping the comments. Okay, there's a question which I am not competent to answer. Somebody has asked how to study for last 20 days. I'm not sure if the person has actually started the work or planning to start. I'm really not competent to answer that. I started the preparation of training people months ahead. Probably it's been the 4th month we have been preparing people. So I don't know any quick fix. Yeah. So I'm not competent to answer that. Please share a sample draft. We'll be sharing that. Claim should be functional part of the invention, not concept. What should be written while starting claim? I claim or we claim? See, if the question says you are a group of inventors, then you will say we claim. If it's a single inventor, if the question says it's a single inventor, or there's something where you can say it's a single, use I claim. Can you again share the name of the pending case? The name was not clear. The pending case, the name of the pending case is Monsanto versus Nuzividu seeds. Supreme Court, it's last week it came before the Supreme Court. It's a pending matter, so don't worry about it. But there is a Delhi High Court decision, 2 Delhi High Court decisions, which you can find it from the internet. Okay, Monsanto versus Nuzividu seeds. The subject matter is Section 3J of the Patents Act. Yeah, somebody has answered that. Okay, definition of efficacy, whether as per line report or a standard definition. Okay, efficacy has been understood by the High Court and the Supreme Court as therapeutic efficacy. Okay, and what is therapeutic? Is therapeutic, the court says that it quotes Dorland's medical dictionary and says that what goes towards curing a disease. So just read those paragraphs and have an idea about it. So that should be enough. It's a lengthy 100-page decision, the Supreme Court's decision, but it's a good read as well. So you will understand the various nitty-gritties of the case. The long and short of it is that the court equates efficacy to therapeutic efficacy. So therapeutic is not actually there in the section. So they give an interpretation based on the fact that it's a drug. Can we write the claims only by reading summary? Only by reading summary? You see, there will be a description that the question paper has. So you have to confine yourself to the description, but you will be given some liberty to make your own assumptions as well. Part C is order, title, claims, abstract, important. Yes, if they say a complete specification, then all these things have to be there. In some cases, in the earlier years, they would just ask you to draft an abstract and 5 claims, or the question will specifically say that. If the question doesn't specifically say, then you'll have to draft the entire complete specification. Again, there is a question how to utilize the balance 20 days before the exam. See, there is quite a lot of material that we have done. Maybe you should listen to the podcast by Lakshmi, where she had actually given a quick way to understand that. But I strongly believe in the long drawn approach. So I don't have any. As I said, I am not competent to answer that question. Abstract shall commence with title. Please explain. Yes. See, title is separate from abstract. Okay. The rule says that the abstract shall commence with the title, but the title and the abstract are 2 different things. Title has to have less than 15 words. Abstract has to have 150 words, less than that. Okay. So these are 2 different things. You have to mention them separately. Can we write claims first, followed by other parts? No. The patent specification has a structure. It starts with the title. There is a separate abstract page which can come at the end or before. Then there is a background of invention, brief description, summary of invention, brief description. There is a pattern. And if you have done our course, you will know that you have to follow the pattern. The claims, in fact, 10.3c says that end with the claims. You should see the language in the statute. So don't start with the claims. The question looks to me that whether we can start with the claims. No, you can't do it because you're going against the statute. Section 10(3)(c) tells us that it shall end with the claims. So you have to end with the claims, and you can't start with the claims and followed by the other parts. That's not permissible. Prior art, whether based on summary disclosure or can we frame? No, don't go to the thing of framing your own prior art, because okay, 10(4)(c). Sorry, 10(c)(4). Okay, you'll find it out. It's in 10(c). It says ends with the claim. So you can't start with the claim. Okay, coming to the next question. Prior art, whether based, whether you can frame your own prior art. Please don't do that, because you have very limited time, and the idea is not for you to describe the prior art. See, drafting is completely different from describing the prior art. Description of prior art will come when you do a prior art search. You identify prior art. And why do you want to mention prior art? You'll only want to mention prior art when you want to show some kind of a teaching away or some kind of a leap from the prior art. Otherwise, you don't. Some of the best drafted patterns don't even mention the prior art. So bear that in mind. Don't create your own prior art, and don't spend time on that. You won't be graded for that. I'm absolutely clear that your grading will not be for the prior art that you frame on your own. It is rather for the other parts that you will have to describe. Please do propose situation-based questions. Okay, for situation-based questions, now in the next week, we will be completing, we already have close to 20 revision tests. By Monday, we'll be uploading 25 revision tests. Now that will complete our revision test part. Now, we will also be loading at least 3 model papers. And in the model papers, you will find the situation questions. I think roughly we will have at least 8 situational questions, translate to 24 situational questions totally. So that will be done next week. We are working on it. So once that is done, you can try all the 3. So it will be added as a part of our practice test course. So if you have already subscribed to that course, you will be getting 5 more revision tests and 3 model exams. Model exams are proper paper 1, paper 2. So it will have all the situation-based questions that you need to look for. Do we just blank sheet with the diagram? Diagrams from question paper? But in the answer paper, do we just have to blank sheet with No, I didn't understand the question. Did it mean do we have to repeat the diagrams? No, please don't spend time drawing it. You can just mention it, cross-reference it. That's enough. Complete specification ends with claim. Okay, thank you. So that, I mean, we are gone beyond our time. So what we will do is we will schedule. I have some travel coming up. So I have my colleagues, Mr. Aslam, you would have heard his podcast. There are 2 podcasts of his. He's a registered patent agent. So he will be taking some tips on drafting. So you can actually, and we will also have an interactive section next week. And by the end of next week, I'll finish my travel. I'm back here. So we'll have more webinars after that. So you'll be having webinars with very short notice. I know that there are people who want to know how to prepare in 20 days. I don't have an answer for that, but at least we can have more of these interactive sessions. So thank you so much. Whatever further questions you have, the best place to raise it is the forum. And I see great benefit in raising issues in the forum. It's searchable. It gives us enough time to answer it with references. And more importantly, if anybody has follow-up questions, they can also raise it. So thank you so much. So we will be on the watch out. We will be giving you very short notice. And some of you are really keen on cracking this exam, which is great for us. So we will be having more sessions like this coming with short notice. So don't worry if you can't make it on time. The videos will be made available to you. So that's something which we can definitely take care of. Give us some time. We need to edit this. So once it is edited, we'll pass it on to you. Yeah. Thanks for joining. Bye-bye.